Lordship, I beg to mention item number 6 and 7, Lordship. My learned friend.
No, not this bench.
Huh?
Itu bench. Itu bench ada beta aja.
Okay.
Item 1 for orders. Review petition 102/2021.
A petitioner approached Honorable Supreme Court and Supreme Court remanded the matter Miller with a liberty to approach this Honorable Court by filing a review petition Miller, page 130.
Yes,
Page 130.
you seen that.
Accordingly, approach this Honorable Court by filing this review petition.
We ask you a question, is it maintainable according to you?
I don't know, Miller. This is the, as per Honorable Supreme Court Miller, approach this Honorable Court Miller.
So,
Up to this Honorable Court Miller.
so we'll answer what you don't know.
Yes. As per Supreme Court Miller,
No,
petitioner
according to-
approach this Honorable.
We ask you the same question differently. A writ petition was disposed of.
Yes.
Against that, there was a review.
Yes. Also
After the review order was challenged before Supreme Court.
Yes.
And then you withdrew it to with
Liberty.
liberty to come again. Now, what exactly you are challenging? You are challenging the order of review, or you are challenging the order passed in the writ petition? In this review petition, second review petition.
In this case, my lord, I have challenged my lord, a tribunal order as well as the High Court order and review order also. In
Then
that
it will be
case,
barred by second review would be barred. We are not saying so. CPC says so.
Yes. I am confined with the Supreme Court order, meaning the page 130 million. Otherwise, my lord, this case has a merit, me. Good case, me. Tribunal did not give any finding on the evidence of a father, Miller, who the petitioner's name along with the father appears in the voter list, Miller. And in this case, Miller, one admit card, Miller, at the time of lamination, Miller.
No, but if you see, if there's a legal bar,
Yes, Miller.
if there's a legal bar, we
Yes,
can't
that
go
is
into
true,
the
but-
merit.
That is true, Miller.
First is the question of legal bar.
Yes, that is true, Miller.
Is there any judgment that after review petition is dismissed, second time again review can be entertained?
Miller,
You see, Supreme Court merely says that SLP dismissed with liberty to approach the High Court. Supreme Court itself did not grant any liberty. It did not confer upon this court jurisdiction to entertain a review for the second time.
here is page 130, Miller, last paragraph. Needless to state that in case of the petitioner placed before the High Court, she is permitted to approach.
Yes,
Supreme
yes.
Court
Definitely, we have
once
read that.
again,
We have read that.
challenging the main order as well as the order passed in the review petition.
We have read that. Okay, we'll try to search for an answer and dispose it off. You want to say anything? You
No,
support him?
Lordship, may review against the review, Lordship, Lily Thomas case is really
Okay.
states, Lordship.
Okay.
Yes.
Yeah, that's why.
But
This
Mr. A.M.
Wonderful.
Ahmed and counsel for the petitioner, as well as respondents are there, Mr. A.I. Ali for the ECI, Mr. P. Sharma, Mr. G. Sharma. The hearing is concluded, judgment of the order reserved.
complex.
Hence, item 2, PIL Sumo 2 1/2020.
With the confidence glowing everywhere, with the confidence glowing in the faces of everyone, the arguing table, including Mr. Kohli, I think we'll have to work hard.
No, not- Actually, the advantage we have had is for everybody is we are beneficiaries of very patient hearing in a very cool atmosphere. So
But now we'll have to end up because every good thing must come to an end. The longer we continue the hearing, the more difficult it becomes for us to recollect and
and the law may change also. Sometimes
not to recollect is something I have a very weak memory. We are hearing because of the various facets of law involved, constitutionality issues involved.
Absolutely.
With regard to Article 371A, we are gathering so much of knowledge that is prompting us to hear it.
I hope we had the videotapes of those submissions which were made in Parliament.
Now you have AI, you can generate it now.
Yeah.
Times of India every day gives a history of the past through AI generated photograph.
There's that cartoon which comes, Manoj, are absolutely right. Manoj, that it's a very interesting one. Manoj, they related back to the major event of the day.
Yes,
And going back, it's quite interesting.
yes. Yes, Mr. Balgopal.
Please. But yesterday, your Lordship had asked me to look into some of these provisions. There's a Petroleum and Natural Gas Rules 1959. Or particularly Rule 4, 5, and 10. I will just step on that, then we'll move. No prospecting or mining except under a license or a lease. No person shall prospect for petroleum except in pursuance of a petroleum exploration license hereinafter referred to as license granted under these rules. And no person shall mine petroleum except in persons of a petroleum mining lease, hereinafter referred to as lease, granted under these rules. Every holder of a license and every holder of a lease shall in these rules be referred to as licensee and lessee respectively. It's only a question of fact, nothing much of legal significance for the moment. Except to say that you must have a petroleum exploration license. Then, my lord, we come to 5. A license or lease in respect of any land or mineral underlying the ocean within the territorial waters or continental shelf of India vested in the Union shall be granted by the central government. I think this is at 197 or so, we are not concerned with that. Any land vested in a state government shall be granted by the state government with the previous approval of the central government. I want to emphasize first on this. So this says any land vested in a state government shall be granted by the state government with the previous approval of the central government. Here is the catch. Where my liberties get cut.
It also empowers you to have it to do it with the in consultation with the state government, central government.
Yes, I'm coming to that first. That's the next one. That's 5.2, which I did not read yesterday, which your lordship had pointed out. I'm reading here for the moment this. Or I can come to 5.2 also along with this. Every license
Yes.
every license and lease
That's it.
shall contain such of the terms, covenants, and conditions prescribed by those rules as are applicable, and such additional terms, covenants, and conditions as may be provided in the agreement between the central government and the licensee or lessee. I will read again, my lord. Every license and lease shall contain such of the terms, covenants, and conditions prescribed by those rules as are applicable, and such additional terms, covenants, and conditions as may be provided. Additional terms and conditions, my lord. As may be provided in the agreement between the central government and the licensee or lessee. Provided that where the license of the lease has been or is to be granted by the state government, the central government shall consult the state government before agreeing to such additional terms, covenants, and conditions. Now, a very innocuous language. What they are saying is, if the state government is to grant the license, central government will consult. The central government shall consult. You also would see the meaning as though central government is something in the periphery. So in actual terms, it means central government shall consult with the state government. We just see that particular portion. Here the lease is granted by the state government. what is mentioned is not that the state government shall consult the central government. What is given here is the state government before agreeing to such additional, the central government shall consult the state government before agreeing to such additional terms, covenants and conditions. So basically, though the words look very innocent, the kingpin here again is the central government for reasons which I'm going to mention. Next, I'll come to 10 matter. Ten is area covered by a license. Area and terms. Area covered by the license shall be specified therein, and the term of license shall in the first instance be valid for a period of 4 years, which may extend for 2 further periods of 1 year each. The period, the area. Now, what is the present position as the area is concerned? Like, suppose they take, say, about 50,000 square meters. Agreement is for 10 years. In that period, they select a particular place from where they can extract it. All the entire balance area, it's up to them to exploit or not exploit. But that land will be with them, used or unused, for that entire period. And earlier, there were 2 types of contracts. One is the production contract. It's relevant to these rules also. Production contract means, I'll give all this in writing also for your lordship under preparation. As far as production contract is concerned, they will first see the person who is going to invest in the exploration. That person has to recover his amount. Only after that, the owner will get his share. So what these private companies were doing, including multinationals, they would pick up a bogus figure of expenditure. It will be so bogus, the owner of the oil will get nothing. Having detected this unfair practice, the contractual terms changed. It became revenue sharing contract, which means from the day they extract, the government will get its share of the revenue. This is how this changed during the period. Now, when your lordship asked me, why do you want a separate rule here? The first question is, are we entitled to make a separate rule? First is that. And the other question is the central government entitled to make a rule which they can impose upon us? This issue has been answered by the learned Attorney General's opinion that you cannot make a law. Law will mean everything connected with the law, delegated legislation, or whatever it is, to apply it to the state of Nagaland in this context, unless the Legislative Assembly of Nagaland, by a resolution, so decides or approves. That's the first point. The second point is the state of Nagaland entitled to make rules? Because the whole thing ultimately is you don't have legislative powers, that is the submission. To this, I had mentioned earlier also, a resolution by the Legislative Assembly is not a statement being made by the government of Nagaland. It is a constitutional provision given in Article 371A. And the strength of that resolution has been recognized in the Constitution itself, because no act of parliament would lie. So today there is no dispute on that. I'm not going back into the history and all that. So there is no two lines on that. So therefore, if I can stop an act, an act encompasses anything covered by it, I'm entitled to do so. Now the technical point, my lord, why we decided to go in for separate routes. Before I enter into it, the right given to the state is not unfettered if you go by these rules. The restriction even for 53, 54 is circumscribed to 2 points: inflammable substance or public interest. I'm not arguing that again. The effect of this was the production of extraction of hydrocarbons stopped in 1994, that is 31 years back, because of this tussle. And I'll show the exact tussle on the ground. The state of Nagaland has got 600 million metric tons of hydrocarbons to be exploited. We are not in a position to exploit. I'll give the reasons.
Has a query, just one query. Small,
Please.
small query so that you can address independently.
Right.
Yesterday you have said, by referring to the Mines and Minerals Development and Regulation Act 1957, by referring to the definition, you have the act.
Yes.
The minerals have been defined. Minerals includes all minerals except mineral oils. And mineral is defined, so mineral does not include mineral oils. Now, come to your act, page 67, 66 of the writ petition or PIL petition.
Please, madam.
The preamble. An act to provide in the public interest for the ownership and transfer of land and its resources in the state of Nagaland for the imposition of tax
Right, right.
on mineral rights. Mineral and mineral oil are two different things. Now it is only in respect of mineral rights
Right.
and imposition of tax.
Correct.
That whether that includes preamble does not provide for all this grant of mining lease, imposition of tax on mineral rights and mineral oil are two different things. And mineral oil includes petroleum, natural gas and all. And mineral is well defined. So how this mineral oil will come within the purview of this
As
act? This is the
I-
basic.
I will
That
answer.
question may be very irrelevant,
I will answer.
but it looks like,
I will answer. No.
and your page 70. Page 70. Third line, Central Act 35 of 1952. The expressions mine, minerals, and owner have the meaning respectively assigned to them in the Mines Act.
That's right.
So minerals does not include mineral oil. We are dealing with petroleum, exploration, lease, license, and all. Natural gas. Now this act, as
Mines
per the
Act is,
preamble,
Mines Act is different.
as per the preamble otherwise,
Right.
and since you have referred yesterday,
Right.
Mines Act regulation development.
That I talked about.
So the
MMDC.
definition includes, definition itself accepts mineral oil from the definition of mineral.
Correct.
This is what
Correct.
my query is very basic.
I am only saying in that particular MMDC Act, that has been excluded. Then your lordship were to say that it is only talking about taxation. Taxation question comes only after the extraction takes place. It is not an abstract term. I will clarify that, my lord.
That mineral part.
I will clear that. I will show also the oil part. I'll do that. It's not an issue.
Because by the Oil Field Development Act, the statement and objective, this mineral oil part has been taken out from the Mines and Minerals Development and Regulation Act. Right? The very definition of mineral and mineral oil are two different things. As per, and I think that 9 judges bench have decided on minerals, not on mineral oil,
In fact,
perhaps.
no, in fact, as far as the definition of minerals is concerned, when I'm submitting the judgments, I have marked various provisions in the 9 judges bench,
So in the course of your
yeah,
submission, you
which
can-
will fortify those things. I'm including all these points in my submissions also. But since your lordship has raised this point, I'll specifically point out.
In the course of your
Though your
submission-
lordship's questions are generally a little dangerous. But once, my lord, if I can mention the name, former Chief Justice of India, who was a judge here, we were again arguing on this same act. I mean, I think this was meant for some other constitutional issue, I think superannuation case. So he kept on asking me questions. And then I was looking at him, quite spellbound. Then he told me, I think if you are finding it difficult to answer these questions, Mr. Advocate General, don't worry, I won't ask you. I said, no. If I don't answer, I know I'll have no case. This is exactly what happened. I was not prepared for it. Then we caught hold of all our people, we assembled here. Third day we gave the answer. So then the decision came. We'll clarify it. This also occurred to me while reading. It is not part of the pleadings. It is not part of the pleadings. In any event, whether this act is applicable or not applicable, the issues on 371A, the issues on the relationship between the center and the state,
May I, before my learned friend continues, just make one little submission, not to.
I would object to any interference when my submission is going on. You get your time, you kindly. I never interfered
grateful.
even for a second. In fact, when the learned amicus was interrupting, I asked him not to do it. You get your full chance. And you
I'm not
argued for 4 or 5
interjecting.
days. So kindly hold on. Kindly hold on.
Sir, I'm not interjecting at
No,
all.
every lawyer says I'm not interfering and they interfere. We are all lawyers. Let us know.
We are assisting you, sir.
To know
There
that.
is a, there is a direct judgment of the Supreme Court on this point. I was only
Please,
trying to-
you'll get your turn. Don't worry. You'll get your
I'll hold.
Supreme Court has not gone anywhere. It is in Delhi only. Don't worry. Then, my lord. When I said there is no production since 1994, what actually happened in Nagaland? They opened up the oil wells. They didn't take any preventive measures to ensure the leakage of oil.
You are told that we have made notes.
Another thing which has happened is,
They left it as it is and went away.
what were the consequences? It's coming in the press every day. It spread to the fields. It spread to the crops. And many people were affected by all these activities. They just closed and ran away. Not just that. The request by the state to remove all this, no response. Today they are saying we are interfering because of this dangerous, because of the inflammable substances, etc. We are talking about that. That didn't take place. Then, my lord, when the exploitation came to an end, because the student body and others pointed out what the central government was doing, that is why it came to an end. Then, my lord, that's the minute. I'm inviting your lordship's attention in this connection. I'm only drawing lordship's notice inviting offers for exploration and development of oil and gas blocks in India under the Hydrocarbon Exploration and Licensing Policy HELP, Open Acreage Licensing Policy, OALP, bid round 1. This is of 2018. What is going on? Your lordship will kindly see the first page is announcement. The third one is biddable terms. Your lordship has got that, my lord? Biddable terms. Now, the next page of it, following page, page 4, top. I made one page note, I'll come to that. The bidder should bid percentage share of revenue offered to government at the lower revenue point, LRP, which is equal to or less than USD 0.05 million of revenue per day and at the higher point, revenue point, which is equal to more than $7 of the revenue per day. So when you say the bidder should bid percentage share of revenue offered to the government, this is important. The government is not Nagaland. Government is the central government. They are going for a bid. And in the bid, these technical terms which are used is, if so much minimum is there and so much maximum is there, how much will you give us? On the basis of that only we will give you the bid. Right? Now, that should be given to the state government. So when your lordship were pointing out, even in the petroleum rules, etc., that you are quite safe, kindly see how safe I am. And kindly, I will draw your lordship to that one-page note, if I may be permitted to read. My lord has got that, my lord. I have included that. I can give one more copy.
Which one?
I think I have one.
We have it.
Your lordship has got it, my lord.
Yes, yes. We have it.
Your lordship has got it.
Yeah.
Oh. I'll just read that. Just 2 minutes. In the notice inviting offers NIO for exploration and development of oil and gas blocks in India, under the hydrocarbon exploration licensing policy, that's called HELP, open acreage licensing policy, bid round, it is stipulated in para 3(4) under biddable terms that the bidder should bid percentage share of revenue offered to government at the lower revenue point, which is equal to or less than $0.05 million of revenue per day, and at the higher revenue point, which is equal to or more than $7.00 million of revenue per day. A perusal of the NIO would indicate that the role of the state is issuance of petroleum exploration license. This is what is mentioned in that PNG rules. This is all the role is, which is issued at the time of exploration, and the petroleum mining lease when the production starts. 2 types of leases, mining, exploration. During 80 to 86, the bidding was enhanced to international oil and gas companies. From 92 to 95, both international and private companies were allowed to participate in oil and gas exploration. 99, the new exploration licensing policy came into existence. The state was entitled only to royalty, which was over a period of time regularly reduced. The owner's plight is that it was the government of India which was taking the revenue. The government of India has tied itself as the owner, has spelling mistake. Government of India has, yeah, the word is slightly wrong. The government of India has styled itself as the owner of the oil and are sharing the revenue with private parties. It may be of significance to note that in the business of sharing, the private companies refuse to pay the agreed amounts, resulting in blockage of huge amounts of money, which are now pending before the arbitration tribunals. In the year 1988, our import of oil was only 30%, while today the import is enhanced to 87%. Therefore, this policy of the central government is a complete failure, and Nagaland is a clear example where they did not share the revenue government, and therefore the exploration stopped in 1994, where we are having 600 metric tons of hydrocarbon. I'm only pointing out one by one. I have that.
But with the reference to the arbitration tribunals, we find that you are still following the.
I'm not talking about ourselves. I'm talking of their contracts.
No, this arbitration tribunals
Yeah.
is this is between the matter is between whom?
Between the central government and these people who are to pay.
Okay,
We are not concerned.
okay, you're not concerned.
We are not
Okay.
concerned, not at all. We are out of the picture because we don't get anything. It's not, we have to understand, my lord, that we have certain rights. We have certain rights. And even if the constitution provisions were not there, general rights are given to indigenous people as far as their property is concerned.
But then, Mr. Paragopal, we come back to the same query from where we started. You see, if the state government has objections to the manner in which these were taken up, that would be an original dispute in original jurisdiction.
Madam?
That would be a dispute in original jurisdiction.
No, I'll come to that. I'm going to deal with Article 131 separately. I'll come. That is in my, I have to do 31 and the opinions, etc. I will deal with that. Because as far as original jurisdiction is concerned, that is one of the items, not all. I'll come to that.
Because here the limited issue was whether in light of the entries made in article, this list 53 and 54, whether this act would be sustainable. So perhaps we may not like to go into all these things because there's no dispute at all, except for your statement. And perhaps that is the reality. But the fact is that this is not a live issue before us.
Even if it was, let us take it, even if it was. The primary issue was who is the owner of the land and resources. That's the issue.
That's the issue.
Even if we go to Supreme Court, that has to be decided. Question of deciding that does not arise because they have admitted we are not entering into your land and resources. So main issue is over. There is no question of taking this to Supreme Court. I was concerned about it right from the state, right from the beginning. What is the stand today they're going to take? Whereas learned AG and others, right from the beginning, they were not in confrontation with the state. They went by the Constitution. So this issue, if they had not agreed to it, then it becomes an issue. These are peripheral things emanating from this. Apart from that, I'll make brief submission on 131, because that was one of the things your Lordship had told me that when it comes, you give a small explanation. I give a paper book separately on 131. May I proceed, ma'am? This is just of, may let's kindly keep this, madam. I'm not arguing any point. In the Constitution, 131. Constitution. Since we have just entered 131, could I
No, not required.
not? Because since your lordship told me, I'll just take a few minutes on 131. I can just clear it up. After the words, I have the opinions, etc. If it's okay with the lordships.
No, you have made your point that when there is an admission, there's no dispute at all with regard to original jurisdiction.
Yeah.
That's the crux of your
Yeah.
submission.
That is for the present submission. Because they say on the question of which whether a fact or law stands. That question is answered. All others are peripheral. Apart from that, I'll be dealing with 131. A fact which they have not pleaded, I'm not concerned really about that. But in the present case, it cannot be entertained, even according to their own arguments. May I point out, madam? Kindly see 131. May I draw your lordship's attention, madam? 131. Right. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between ABC, the government and one or more states, Government of India and state, and other states on the other side, between two or more states. If and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. I think I don't have to explain this. The whole thing is on the existence of the legal right or so. Now, my lords, let us come to the proviso. The proviso says, provided that the said jurisdiction shall not extend to a dispute arising out of any treaty. Treaty means between two municipal states or two nations. That is treaty. Agreement. It can be within. Covenant. Engagement. Sanad. Or other similar instrument which having been entered into or executed before the commencement of the Constitution continues in operation after such commencement or which provides that the said jurisdiction shall not extend to such a dispute. Are we covered under this? We have the 9-point agreement. The pre-constitutional agreement, 1946 or so. So it is not pre-independence agreement, it is pre-constitutional agreement. Even if it is pre-independence, we are covered. So this 9-point agreement which came in at that time, in which there are various clauses. All the clauses may not be admissible. Even today, they are asking for sovereign rights, some of them. That the position is quite clear about it. But as far as our land and resources are concerned, that was flowing from very early times because they had their own structure. That's why nobody wants to put their finger into it. Even if you want to go in for a transaction of a land, even at the basic level of village courts or whoever village councils, they all get entangled in this. While this was going on, we reached 1960. 1960, we again had the 16-point program. If we were to read the 16-point program, which crystallized into Article 371A that time, we'll see it's almost verbatim the same. So we have a pre-constitutional agreement which survived post-constitution, in fact, which was inserted or embedded completely into the constitution in terms of Article 371A. So these questions were going on, and they are used the nomenclature agreement. 9-point, 16-point, 371, where it merges. The spirit as far as land and resources is concerned, that continued. Protection of that continued. Therefore, in one of the decisions, my lord, judgment here. Yeah, where it is mentioned. If it I told you, I'll just take a minute, my lord. Sorry. How many copies are there? Keep that paragraph. It speaks of 9-point agreement.
So this is argument given by them, it's already filed. This is 9-point, this is 16.
I'm told this judgment has been filed by the other side also. This is State of Nagaland versus Rosemary.
State of Nagaland versus
Rosemary. There's a women reservation matter which they had utilized to show that we didn't follow the procedure as far as passing the resolution is concerned.
You had referred to.
You have produced this.
You had,
I have
you had,
put-
yes, paragraph 24,
Oh, you like
24 to
that.
31.
Well, so therefore,
Hmm.
I'm sorry. Therefore, I'm just drawing your lordships to para 23. My lord has got that.
Yes.
The historical preface of the creation of the state of Nagaland and the Act 1962, assimilating Article
That
3,
is 24.
I think in my.
24.
24 you have referred it. We have marked it.
Yeah,
Para 24 to 31 you referred earlier.
yeah, I'm talking of 23. My lord has got that, my lord.
In the copy you provided to us is the
Right.
GLT printout. Para 24 is the historical preface of creation of state of Nagaland.
Then I'll go by that 24
Uh-huh.
for a minute.
No, it's okay.
I don't know how it has happened.
No, it's okay.
It's different.
So I'll go by what is there at 24.
Hmm.
The historical preface of the creation of the state of Nagaland and the Act, assimilating Article 371 to the constitutional scheme of democratic governance of the country in bare essentials is thus the desideratum. The records testify that a 9-point agreement between the Naga National Council and then the governor of Assam was deliberated upon and inked during 27 to 29 June 1947, recognizing in unambiguous terms the right of the Naga people to develop themselves according to provincial or central legislature, which would materially affect the terms of the agreement or the religious practices of the Nagas, which would have legal force in the Naga hills. Which will have legal force in the Naga hills without the consent of the Naga National Council. It was provided that in case of a dispute as to whether any law did so affect the agreement, the matter would be referred by the Naga National Council to the governor, who would then direct that the law in question would not have legal force in the Naga hills, pending the decision of the government. The consensus echoed in the deliberations between the Naga People Convention with the Foreign Secretary during 27-28, 1960, and the 16-point agreement arrived at clause 7, whereof predicated that no act or law passed by the Union Parliament affecting the provisions of pertaining to, amongst others, to the religious or social practices of the Nagas and the Naga customary laws and procedure would have legal force in Nagaland unless specifically applied to it by a majority of the state assembly. The last portion I'm reading, last two portions. Statement of objects and reasons of the Constitution's 13th Amendment Bill, 1962. Notice this agreement, under which it has been decided the Naga Hill Tuensang area, a Part B tribal area within the state of Assam, was formed into a separate state or the union, amongst others, with the aforesaid regulations restrained on the application of the Acts of Parliament on matters pertaining inter alia to religious constructions, customary law procedure. The statement of objects and reasons further recorded that these aspects were peculiar to the proposed new state of Nagaland, warranting the provision in respect thereto made in the Constitution itself. The proposed bill thus sought to amend the Constitution to provide for these matters and those ancillary to it. The statement and object reasons also refer to a separate bill. Then, may I read just two more paragraphs, my lord, 26 and 27. That must be in your lordship's one paragraph before, maybe 25 and 26, if I'm right.
We have in fact marked it. You last time also read it. We have marked it.
I'm sorry, my lord, again, I committed the same oversight. The extract of the debates of the Constitution, the Lok Sabha, emphasized upon the assertions of the Prime Minister of the country to extend maximum autonomy to the Nagas in their internal affairs while accepting their demand for a separate state by 371. The necessity of such a provision, while dwelling on the another provision, was affirmed in view of the special conditions that prevailed in the area concerned. While dwelling on the essentiality of the independence and autonomy of the Naga people without interfering in any way in their internal affairs and ways of life as a guarantee to effectuate university and diversity, the powers limited though of the Legislative Assembly as envisaged, the proposed constitutional provision was affirmatively ratified. The debate on this bill in the Rajya Sabha too recalled the history of the Nagas, their traditions, cultural background, to merit a different treatment. The Constitution 13th Amendment Bill 62 and the state of Nagaland will continue to be an yield of the realization of the exigency of justice to these tribal brethren of the nation who had their own form of democracy governing their respective tribes, being guided by their customs and religious beliefs and practices demanding safeguard thereof through conferment of autonomy deserved by them. Article 371 is substantially a replica of the corresponding clauses of these agreements referred to here and above, or the application of the Acts of Parliament to the state and reiterated. So, my lord, I was reading this only for this purpose. That a division bench of this honorable court has affirmed, but they have given maybe whatever I had argued, all that condensed form of it is here in this provision. And one more point on 131. We are aware of the fact that who will be the parties before the court. Long discussion has been made even by my learned friend, saying that Article 12 state, which includes authority, that will not be applied here in 131, because the beginning of 131 says be the parties. And even if a party is a government corporation or an authority, they can't be brought in 131. Likewise, a private individual also cannot be brought in. Now, in this particular petition, who's respondent number 7, my lord? Respondent number 7 is a private party. That is the Metro Oil who are getting the contract. So, question of referring this in its form under Article 131 does not arise even according to their own submissions.
In fact, we can't make a reference. We can merely we can merely couch our words so that you get an leave or license to apply.
But as far as reference before this honorable court is concerned, though initially that was a preliminary view that we will refer it as a PIL whatsoever.
No, reference is not a reference per se as we understand in the Civil Procedure Code. It's not a reference like
No.
that.
just when the court on its own motion.
Because even our High Court rules otherwise do not prescribe. It merely says that it will be for issues of right will refer to a larger bench.
So here is the situation where, my lord, the actual position is that as far as the dispute is concerned, one limb of the dispute is the grievance of a private party getting or not getting the license. The private party cannot go to Supreme Court. Incidentally, when this question came, these issues were pointed out at different stages. And as I have just pointed out for the sake of repetition, the primary issue which was once kept open has attained finality before this court. That is all. So now, as far as the private party is concerned, he is having a grievance pertaining to these things. And as far as we are concerned, in the light of the fact the law is in our favor and they have conceded to that, what should be our position? It's definitely within the purview of this honorable court.
You can take a seat. You can take a seat.
Where's that pen? Only the thought. Give me 131. Constitution. Therefore, my lord, I urge three grounds for your lordship's kind consideration. The first being, this no more involves a dispute of a question whether of law or fact, on the basis of which the existence of a legal right depends. Or in fact, if this provision was clear at that time, my lord, this matter we would not have gone through. But here the central government was faced with a difficult situation where if they don't make this statement, my lord, that would amount to violation of 371A. So that is why they have rightly segregated it. So apart from this, the fact that there is a pre-constitutional agreement which has traveled, which is given in the proviso, if that situation arises also, 131 will not come. And finally, this being a dispute, there are private parties involved, his rights are there. How much their rights are valid or invalid is a separate question. But the fact remains he is a party. So on all these counts, 131 is ruled out. Then as far as this reference is concerned, this was only an initial view. It was no judgment was passed. Only an initial view. And in all fairness, they kept it open. Let us go ahead. A path was started for us. And after going through the path, there is justification for this point that it cannot be referred to Supreme Court. It's something, it's not a case of a larger bench. No judgment has been passed. Just at the inception, in all fairness, they said, stop. So that is something squarely which my lords can decide. And I don't think on that there can be any objection. Even if there's an objection, I will satisfy. Then I also emphasized yesterday that when we have been given such an important constitutional provision, which has not been given to any other state in the country, no state court, even Jammu and Kashmir did not get it. The word resources. Therefore, my lord, having given it to us, where is that 371A gone in its applicability? The state should be protected. It's a small state. Kindly see our problems, my lord. We have various problems which are maybe prevalent in some states in different degrees. Very limited resources. And even your lordship would see that in the 9-point and 16-point agreements, there's an agreement that they will give us grants, central government will give grant. So our revenue primarily for major investments comes from these grants. And it is not that we want to perpetuate this grant aid. If we have our own resources, we will be able to survive. And if 371A has been appreciated in its right perspective, with the intention in which it was enacted, portion will be different. It is being watered day and day. I can understand, my lord, just for the sake of a small point. This is exactly what the colonial powers are doing in every part of the world. They have, wherever you have resources, when they're leaving the country, like Africa, current problem, a continent is 54 or 55 countries, all these European powers who were colonizing this, without exception, they got into agreements with them. The reverse of Article 371A, saying, we are giving you freedom, but all this is ours. And there, what they did, they took away the resources. Africa remained poor. And with this wealth, which they sold in many thousand times more, there everything was set up. Now this bluff has been called off by the African leaders, especially a very famous leader, Ibrahim Traoré, in one of the states, where he said, any land given to any foreigner is no more legal, one shot. The law is very simple, no complication. With that, everything goes. Because when your lordship says, what is the, where are you covered? I'll come to that land question also shortly. So therefore, they were told, then they got their army removed, they got their own currency started, and today, one of the nations which had a debt of $4.4 billion has cleared it and told the IMF, we don't want your money, you are self-sufficient. So that infectious point has spread through various states. We are like that in a different way, except we are not a separate nation. We are part of the country where we have been given assurances. We are only asking in simple terms, whatever be the interpretation, we have to be protected under Article 371A. That is one of my main submissions here. We have to be protected. It is given to us, an assurance. I'm not speaking of estoppel and other things because it's a fight between a center and a state, definitely an avoidable one. No, my lord. We will for a moment see list 2, my lord. I draw your lordship to list 2. My lord has got list 2, entry 18. Land, that is to say, right in or overland. So the entry is not land, in, at. That is to say, right, land, right in or overland. So when there is anything inside the land, by various decisions, even I think reference is given to that larger decision which has been quoted, that includes the resources. The resources are 100 types of resources. You cannot specify this resource or that resource. And one of the resources is the item we are talking about. All this is covered because it's under the land. Even if it was just land, there are decisions, what's the meaning of ownership of land. So when you say land in, I am 100% covered. And they cannot say under this provision or that provision, I don't have any entry on the basis of which I can make a law. None of the minerals are mentioned here. None of so many other things are not mentioned here. But if it is something of worth which can get benefit to that state, then that is covered under land in. Because the judgment which you want to apply. Judgment which you had prepared, no? The various judgments. Property underneath. These are packaged, okay?
This is the 9 judgment that we
Okay, fine.
can ownership of the property.
Ownership is this.
The four judgments on ownership. One. Each of this is a 9 judgment. This is also ownership. 251. 259.
I just forwarded, I'm only drawing your attention to what I have flagged. All the others, my lord, are an answer to their judgments, some of them. The first portion of this deals with ownership. What exactly is ownership? I've come to that separately because if I read the decision, it will take time. Therefore, I'm just abridging it and we'll be putting it along with our submissions with the page properly indexed so that your lordship can take this as a reference point. You kindly see, my lord, and many of these are coming from this 9 judges bench judgment only. in that para 48, the first portion which I flagged green. Para 48, Your Lordship. Para 48, in that judgment, it is given as 276. My lord, got that, my lord? Two seven six. I may read it. In S.R. Bombay's case, Justice B.P. Jeevan Reddy observed that the court should be circumspect in adopting an approach or interpretation which may have an effect of whittling down the powers reserved to the states. That is, this is para 48, maybe. I think that's maybe one para above or below. My lord. Correct, that's it. Then, my right, the fact that under the scheme of our constitution,
We have marked it earlier. That means you have read it, I think.
wait. I'll just read this only 4 lines. I'm giving these copies so that it's a little brief, but once your lordship has gotten the main, as your lordship says, there will be no confusion. Can I read just that one?
Yes,
paragraph?
yes.
Please. The fact that under the scheme of our constitution, greater power is conferred upon the center vis-a-vis the states does not mean the states are mere appendages on the center. Within the sphere allotted to them, states are supreme. The center cannot tamper with their powers. More particularly, the court should not adopt an approach and interpretation which has the effect or tendency to have the effect of whittling down the powers reserved to the states. That's what I'm reading. Now, on the same page at 251. My lord has got that where? 251. The general rule in England was the rights of an owner of land extended to everything in, on, over land. So that word in is coming here. And this has been explained by such and such judgment. All of details are given. Then 259. Next page, 259. There's pat on the point, how our courts are dealing with it.
You are referring to which paragraph?
Now I have come to 259.
It is in which page?
Oh, this 319? 319. 319. No. Page 152. Page 152.
Of the judgment. Yes.
And the para?
259.
Page
152.
152 of the judgment, my lord. Sorry. Page 152. Para is 259.
It starts with, the paragraph starts with what words?
Raja Anand.
Raja
Rama.
Anand,
Raja, yes, 259,
my lord of God. Right.
259. Yes.
No, I'll just read in this. Constitution bench accepted that the English system of ownership of lands applied in India, observing that the owner of the surface of the land is entitled ex jure to everything beneath the land. It was further observed that a transfer of the right to the surface conveys the right to the minerals underneath, unless there is an express or implied reservation in the grant of land. And this, they have quoted this Thelissima Jacob, which was dealt with elaborately. Then Department of Mining and Geology, the view given by the courts that you have to look into the issues right from the beginning. Keep it outside. You know, say,
Yes.
We'll take a break and come back.
I was wondering your lordship had forgotten about it. We were also waiting for it.
In your compilation, you can give us those paragraphs.
Which one?
In your compilation you are wanting to make,
Well,
in that you can give these paragraphs.
thank you.
Hmm.
Not only that, my lord, even specifically I'll address those questions also as far as the gas petroleum rules of course. I'm just modulating it in such a way, my lord. Look at this and a comparison with that. And if required, we'll mail separately the judgments also in detail, so that there is no confusion. I'll see to that there is no overlapping of the page also. I'll recheck. Sometimes it is taken from different books.
Yes.
So a small, that's a big error, because when you read it, you don't find it. Unless you are able to tab that it is one number below, one number above. That's the difficulty.
The problem is with SCC, they create paragraphs.
Yeah.
Which is not there in the AIR or other e-journals. So when we compare it from the e-journals and then
It
SCC,
will be different.
SCC is more cited, therefore we refer to SCC. But it creates paragraphs. It also changes the order of judgment. The larger bank comes, if it is a Chief Justice's order, then it comes first. there's a different order, so I find it very difficult at times.
Actually, they're not supposed to do it. Go by the judgment. If there cannot be any type of reclassification of the judgment by any authority.
So we understand, but
Maybe it is a,
You'll have
people are
to-
not used to it.
you will have to raise it in the Supreme Court because
It is in event, they're not changing the matter. Even if you change that, everything has got an importance when we read it. So it's not that the other persons who have given the judgment later, it should be given in the form in which the judges. They alone know how it has to be given.
yes,
That's a serious problem. Though we are coming out with so many other editions of the Supreme Court itself. Things by the number of judgments are just coming in torrents. Even to read the gist of the judgments which are coming every day, even from one court, is difficult.
Pepsi has the last word.
My lord,
Pepsi has the last word. Dil mange more.
now, my lord, I'm just touching upon another important issue here. I've given the different views of the courts, the interpretations, etc. Now, in this connection, we also took assistance of eminent legal luminaries and jurists, different, raised similar questions because sometimes it may vary from one person to another. Not that all of them have to be equal. Because I concede, an opinion is an opinion. I do concede, whether it is Attorney General's, an opinion does not bind the court, even if it is Attorney General, or even if it is a retired judge. It may bind the state, my lord. If the Attorney General makes a statement in the court on behalf of the government, then in a way the government gets bound. That's the only difficulty is there. Notwithstanding these facts, these are great legal luminaries who have gone into each and every aspect. So this perhaps will answer many questions. And this was done, we are today making submissions on various issues. Some may be presumptive, some may be what is on record. But the coherence with which they have addressed this issue is really remarkable. And I will point out to your lordships some of these things. Incidentally, my lord, these written submissions, I mean, these on this particular point, when I say written submissions, this was on the views of the jurists. My lord has got that, my lord? May I read it for your lordships? Every word is important, your lordship.
Which one?
I've submitted,
Okay, written submission.
though I've written submissions that has been wrongly mentioned as written submissions. These are actually the opinion given by the various jurists. I'll redo it and make the correction. May I read, my lord? First one, my lord. Lota Oho versus State of Nagaland. A resolution was passed, my lord has got it, my lord, first page, was passed by the Naga Legislative Assembly on 26 July 2010.
I think you have separately given us this opinion, Solicitor General opinion.
No, Solicitor General opinion I have given separately.
Yes.
But I will start with this. The other opinions I'm going to address. This is the opinion which was controversial because according to them,
No, opinion will take your written note. You may not address us on this.
okay, then let us leave
Because-
this,
Uh.
this portion. Let's come to the next.
Because we have another issue with regard to time.
I
The
know, it.
bench is very difficult to be here.
I'm aware of.
Mm.
Today I will just make submission for 10-20 minutes, that's all.
Mhm.
Then we'll see next what is to be done.
You can take it from us. We'll consider this.
No, but some of these points are relevant because
Yes.
this answers certain queries which have been raised. Kindly permit me. Because the theme of this judgment is that we agree that as far as entry 53, entry 54 is concerned, they have an overriding effect, all that is there. But everywhere it is marked. This is not the case as far as state of Nagaland is concerned. I want to emphasize that. Permit me to do that, my lord, as far as at least one or two opinions. I won't take much time. May come straight away to internal page 7. My lord has got that now? That is serial 8. According to opinion of H.M. Sirwai,
Yes.
dated 1980, he replied, I do not know whether there is anything in the agreement between the Government of India and Nagaland People Convention on this point. That is on 371A. But even if there were, for reasons already given, they cannot be used to explain or interpret Article 371A. However, the plain meaning of the word land and its resources shows the right to mining major and minor minerals and the right to oil, which is a natural resource of the land, belongs to the owners of land in Nagaland or to transferees of land in Nagaland. And these resources cannot be affected by a central law unless the legislature of a Nagaland assents to it. There is no direct authority on this point. The only objection I can think of against the view expressed above is that it would introduce in Nagaland an unusual system of government under the Constitution in respect of certain subject. But then the statement of objects and reasons clearly show that the special provisions peculiar to Nagaland had to be made, and the provisions mentioned in paragraph 2D of the statement of objects and reasons have in fact been incorporated in Article 371A, 1A, 1 to 4. Secondly, there are other provisions during the transitional period which clearly depart from the scheme of constitution for the government of a state. The provisions in Article 371A to D that for a period of 10 years which may be extended, the governor may make regulations for peace and order, the widest legislative power which a constitution can confer on the head of a government. And these are powers conferred, notwithstanding anything in the constitution. I would therefore answer the queries put to me, saying that land and resources in the plain ordinary meaning of the word resources includes mining, mines and minerals, and also oil, and for the reason already given. The state government has power to pass legislation in respect of it. Secondly, the state can levy taxes on mineral rights, subject to any limitation imposed by Parliament by law relating to mineral developments. A law for mineral development would be a law in respect of land and its resources, and such a law cannot apply in Nagaland unless assented to by its legislature. The state power under entry 50 list 2 is not taken away. I do not know whether in fact any limitation has been imposed by Parliament by law relating to mineral development so far as tax is concerned. There is no such law. Then independently of what I said, the state can impose tax on mineral rights. In view of current political controversies, it becomes necessary to say The above opinion is a legal opinion dealing with the points of law which arise from a construction of 371A of the Constitution and the change which the Constitution 13th Amendment Act was intended to bring about in Nagaland, as indicated in the statement of objects and reasons. On the same issue, my lord, Mr. Nariman Papan, very brief one. He stated that the principal question on which my opinion is sought is the width and scope of the price land and its resources. Everything is boiling out to the main issue. In my opinion, that phrase would necessarily include the natural resources of the land and would obviously extend to mines and minerals. In the Constitution of India, lands and minerals included in the ocean within the economic zone as treated as resources. And Article 297, read with 297(2), all other resources. After the 13th Amendment, the provision of Mines and Mineral Regulation and Development Act, 1957, enacted by Parliament in exercise of legislative powers conferred by item 54 of list 1 of the 7th schedule, would cease to apply to the state of Nagaland. This act is in respect of ownership of mineral resources. It prescribes inter alia the procedure for obtaining prospective license or mining license in respect of land in which the mineral vests in the central government or the state government. See section 10(4) and section 17. Besides the ownership of mineral resources in the central and state government, royalties, fees, and other levies are authorized. Besides the extent of the legislative power of Parliament under entry 54 for regulation and development of mine and minerals under the control of the Union includes necessary implication of the power to acquire mines and minerals. The Bengal case, which is quoted. The legislature of the state of Nagaland had and continues to have plenary powers to enact legislation. Under entry item 23 of list 2 of the 7th schedule, regulation of mines. Though item 23 of list 2 is subject to the provisions of entry 54 of list 1, and in spite of the provisions of section 1(2) extending the mines and mineral regulation to the whole of India, and in spite of the Parliament declaration contained in section 2 of 57, the Act, the effect of provisions of Article 371A, 1 to 4, is that unless the Legislative Assembly by resolution so decides, neither this Act nor any other Act in Parliament, ownership and transfer of land will apply. So it's not just this particular Act on which my lord had raised the question, any Act. The question of land and resources is one of extremely wide import. It is well settled that under normal normal connotation of the word land would include minerals, but in the Constitution of India, apart from the special provision like 371A, the expression land as an entry relating to a head of legislation only covers rights in or over land. See section 18, list 2 of the census. Mines and minerals and the development is separately provided for. It is in this context that scope of expression land and resources is to be ascertained and understood. Those who have drafted the 13th Amendment must have conscious of the existing constitutional provisions and existing constitutional difference between right in and over land and mine and mineral development. At least that must be the assumption. Yet they chose a phrase of wider importance so as to cover not only land, but also resources. The second question is whether under 371A, the Act of Parliament referred to would only cover post 13th Amendment or would include each and every Act of Parliament. In my opinion, the matter does not admit of any doubt. The 13th Amendment says no Act of Parliament in respect of such and such shall apply to the state of Nagaland. This only means no legislation, past or future, passed by Parliament, is applicable to the state of Nagaland if it is a legislation in respect of one or more enumerated items. The third question relates to the effect of Article 371A on legislative powers of the Legislative Assembly of Nagaland. In my opinion, there being no amendment to any of the items in the 7th schedule in relation to the state of Nagaland, the Legislative Assembly would be empowered to pass such law, or any other state legislature would be empowered under list 2 or list 3. But with regard to legislation relating to mines and mineral development, since the mine and mineral development has become constantly inapplicable to the state of Nagaland, with effect from December 1963. The plenary power of entry of List 2 would be a legitimate source for any legislation falling under this entry in the territory of state of Nagaland. The Mine and Mineral Regulations and Development Act 57 is an act of parliament. Although it says it extends to the whole of India, the width of its operation is limited by the 13th Amendment with effect from 1st December 63. It no longer applies to the state of Nagaland. The effect is that the Mines and Mineral Development Act, with effect from 63 to the whole of India, except the state of Nagaland, neither the theory of occupy a field nor denudation of power would preclude the state of legislature of Nagaland from enacting appropriate legislation with respect to the regulations of mine and mineral development. It necessarily follows that any legislation under entry 50, list 2, taxes on mineral rights would also be subject to, with reference to which the Nagaland would be entitled to legislate. In my view opinion, by reason of Article 371A and in view of the non-obstant clause in its opening part, the subordination of the legislative power to the paramount parliamentary power in items 23 and 5th of list 2 would no longer be applicable. This answers all the submissions contrary to which this opinion is coming. The last one, I'll read just 3-4 pages. So, Sarkar. RC Sarkar has opined as under. There is a reference to land and resources in clause A of Article 371A1. And the word resources, as we shall see later, would include mines and minerals. The Mines and Mineral Regulation Development Act or any other central law for regulation of Mine and Development Act would be a law in respect of land and its resources within the meaning of clause A of 371. And even if such law was in force in Nagaland, such laws shall not continue to apply the state of Nagaland unless its legislative assembly so decides. Having regard to the foregoing considerations, my answer to question number 1, that is, in my opinion, no act of parliament in respect of matters referred to in clause of Article 371A1, whether passed before 63 or after that date, would apply to the state of Nagaland unless the legislative assembly of that state by a resolution so decides. State of Nagaland being formed on 1st December 1963, Article 371 has only a prospective application. This article is not of a repealing nature as suggested in the statement of case. Acts of Parliament passed before are not repealed, but the application is barred from 1 December without the consent of the Legislative Assembly of the state. I shall now take up the question whether, which relates to the ambit of legislative powers of the state of Nagaland, in respect to entries 18, 23, and 50 of the state list. Entry 18 relates to land, and the scope of this word has been fully explained in the Constitution itself. It is a state subject, and Parliament has no competence to legislate with respect to this matter, and every state legislature has plenary powers to make laws with respect to this entry without being subject to any control of Parliament. Entry 23, however, stands on a slightly different footing. It reads as follows. Regulation of mine and mineral development subject to the provisions of List 1 with respect to regulation and development under the control of the Union. The powers of the state government in respect of this matter are absolute. They are subject to the provisions of entry 54 in List 1, and entry 54 reads as follows. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. I'll read the next. Parliament has, my lord, that is
Yes.
after 54 on page 13, my lord has got it. Page 13. After 54. . Parliament has enacted certain laws by making necessary declaration under entry 54 of list 1, such as Coal Mines Safety Act, Mine and Mineral Regulation Development Act. The legislative competence of a state legislature to enact law with respect to entry 23, list 1, when Parliament has enacted a law by making necessary declarations under 54, has been settled by the Supreme Court in the case of Hingu Rompur Coal Limited for the state of Orissa. The Supreme Court observed as follows. The jurisdiction of the state legislature under 23 is subject to the limitation imposed by the latter part of the said entry. The Parliament by law has declared that regulation and development of mines should in public interest be under the control of the Union. To the extent of such declaration, the jurisdiction of the state legislature is excluded. The limitation imposed by the latter part of entry 23 is a limitation on the legislative competence of the state legislature itself. This is not in dispute. If a central act has been passed which contains a declaration by Parliament as required by entry 54 of list 1, and if the said declaration covered the field occupied by a state act, the state act would be ultra vires, not because of repugnancy between the two statutes, but because the state legislature had no jurisdiction to pass the law. The leading case on this subject is State of Orissa versus Tulachand and Company. That case considered the provisions of the Mines and Minerals Act 1957, which was enacted after making necessary declarations under entry 54 of list 1. After examining the various provisions, particularly section 18, Supreme Court held that the whole of legislative field regulation of mine and development has been covered by Parliament declaration. And for all practical purposes, state legislatures have been deprived of the power to legislate in this field. In subsequent cases also, the principle was followed by Supreme Court in Bajanath Kedia versus State of Bihar. I shall now turn to entry 50 of the state list, which reads as follows. Taxes on mineral rights subject to any limitation imposed by Parliament relating to mineral development. The principles which have been evolved for determining the competence of state legislature to legislate with respect to entry 23 of list 2, when a declaration has been made by Parliament under 54 of the Union list, shall apply to 50 of list 2. In other words, a state legislature will be deprived of its powers to impose tax on mineral rights to the extent to which Parliament imposes a limitation by law to the mineral development. A combined reading, my lord, of entries 23 and 50 of list 2 and entry 54 list 1 establish that so long as Parliament does not make any law in exercise of power under 51 of list 1, the state will have plenary power to make laws with respect to entries 23 and 50 of list 2. But when Parliament makes any law for regulation of mine and mineral developments by making declaration under entry 54 of list 1, the power of the state legislature with respect to entries 23 and 50 would get denuded to the extent to which such regulation and development is covered by the declaration. We have also sent the Mine and Mineral Development Act occupies the entire field of regulation, and the state have been virtually deprived of their powers to make any law. The aforesaid observations are applicable to all the states in India, but not to Nagaland. This is the distinction, which has been accorded a special status under 371A, a law of Parliament regulating mines and mineral development, enacted in exercise of power under 54 of list 1, is a law within the meaning of land and resources referred to in class A of Article 371A. And I have taken the view that such law would not apply to the state of Nagaland without the consent of its legislative assembly. I presume no consent has been given. My answer to question number 3, therefore, is the Legislative Assembly of Nagaland had plenary powers to legislate with respect to entries 18, 23, and 50 of list 2 without being subject to any control exercised by Parliament by law. To sum up, in my opinion, no act of Parliament in respect of matters referred to in class A of Article 371, A1, whether passed before 1st December 63 or on after that date, would apply to the state of Nagaland without the consent of the Legislative Assembly of the state. In particular, laws of Parliament regulating mines and mineral development enacted in exercise of its powers under entry 54 of list 1 would be laws within the meaning of land and its resources referred to in clause A of 371A1 and would not therefore apply to Nagaland without the consent of the Legislative Assembly. I presume that no such consent has been given. That's correct, madam. The Legislative Assembly would therefore have plenary powers to legislate with respect to entries 18, 23, and 50 of list 2 without being subject to any control exercised by Parliament by law. The position that emerges is, though Nagaland is a state within India, it has been given a special status which distinguishes it from other states. Whether such provisions would affect uniform development of our resources, which is outside the purview of this legal opinion. I will come back to this. No, I'm just coming to the last point. So, my lord, this opinion, notwithstanding the 9 judges bench judgment which came subsequently, it has laid the foundation of law as far as this is concerned. They've gone into various aspects. I'm just going into the last line, whether such provisions would affect uniform development of our mineral resources matter, which is outside the purview of the legal opinion. In fact, here is the case that though we have been given the powers under 371A, we remain where we were when we started in 1963. We have not got any benefits from this. Whereas if this interpretation given by the learned jurists on this is accepted, then we would have been entitled to all the benefits which was flowing there, which we have been deprived of till date. There are more opinions which I'm not reading. I'll restrict myself to this. Now, my lord, and just for my lord's on the page 17, historical aspects which culminate in the enactment. I'm not reading out, I'm just pointing out. So that is it, Acts of Parliament. Then the statement of objects and reasons of Constitution. If that is not on record, I'll just place it for your lordships.
I think
it
you've
is
given
not
that.
there. Statement of objects.
Statement of objects you are given.
It's given, my lord. Can I have a copy? Statement of object.
Yes.
My lord is having that, my lord.
Yes, I think you gave it.
The statement I have not given. I've mentioned about it. Just for my lord's record.
Yes. Okay. Or
You've given it earlier.
Is good.
Hmm.
Only the first page, Acts of Parliament shall not apply. And the third paragraph on the first page. My lord has got that, man. As these matters are peculiar to the proposed new state of Nagaland, provision with respect thereto has to be made in the constitution itself. So at each stage, my lord, what's happening here is a constitutional guarantee has been given. A large component of that guarantee is today not under dispute. And even the dispute raised, as far as the regulations are concerned, under 53 and 54, though they may appear tenable to look at, because dangerous inflammable substances are there on one point, and second is in public interest. These regulations are being used as a canopy by the central government, by their misinterpretation, to control the state of Nagaland from exercising its rights over something which it owns. And what are the rights of ownership, Anand case, etc., in the bunch of decisions which I have given your lordship, everything is mentioned. I am not taking your lordship time on that thought. So in these circumstances, not giving the state of Nagaland all these benefits, in my humble opinion, is a clear betrayal of the guarantees given by the state, by the central government to the people of Nagaland. Secondly, my lord, I have clearly explained, subject to your lordship's views, of course, as to how the owner of a resource is treated by the central government. Where we have been at the mercy of the central government, which has in the constitution limited rights of regulation. They cannot take away the rights of ownership, and in writing it has been declared that they are the owners. I have, during my earlier arguments, my lord, submitted two agreements, thick agreements. One was with ONGC and the other private part, Crane or whatever, I forget the name. That other was with Oil India. Oil India is directly only pertaining to Nagaland. The other one was substantially of Assam, a little portion of Nagaland. They should there also do it. There in writing, they are saying we are the government. No mention of state government. So can they protect this type of conduct through the regulations, through entry number 53, through entry number 54, or has there been a blatant usurpation of powers not vested with them under the Constitution, and have they wrongly taken away these rights? Why I said that most of the positions have been admitted is the ownership and transfer of land and resources accepted. Now, whenever we go to sign agreements, there's something going on as far as the disputed area belt is concerned. What is the disputed area belt, my lord? That's about 512 kilometers. We are dealing with that in the Assam-Nagaland border dispute, where both the states have decided that let us explore and exploit the oil on this area. Assam has been exploiting this oil. Nagaland has not been, because it was disputed area. Now they are trying to arrive at a state by which both the states can make use of that. But whenever the agreements came, when we inserted 371A, the officers would back out, as though they felt they was doing something wrong. So in effect, there has been no acceptance, tacit or otherwise, of Article 371A. So therefore, my lord, this question has to be looked into from this particular angle. That so much, the serious situations in which the state was absorbed as part of Indian territory with no preconditions except these special provisions. Having done that, my lord, in a small state, we don't have any revenue. We don't have revenue even from central excise. Industry is very limited. The only gain in the last 20 years is there is perfect law and order in the state of Nagaland. And for your lordship's information, in the whole country, the criminal cases in Nagaland is the minimum today. This is not our census, it's the central government census. So that is in effect a very, very great achievement. But to make it go further, my lord, we need the income from these resources. We are morally and legally entitled to this. This question can also be looked into. Now I have a few judgments and a few explanations to make, which I'm not making today. That won't, anybody, they can argue whenever they want. Just about 5 minutes, either when they're arguing or after that. I will just clarify those judgments because I'm not, because my learned counsel had utilized a lot of time only in reading judgments. I'm not doing that only to save time. But at the same time, I should draw your lordship's attention to some specific points. Permit me to do that. Maybe. In writing, I would say 10 minutes, not like what I said earlier and I took time. I won't do that. They are free to make their submission. Give me only that liberty. Either after they argue, what I want to say about the
No,
submission.
because if you have to do that, then you'll have to continue.
I am saying I can continue for 10 minutes or 15 minutes when I
Ah.
organize those points. I will do it. No problem.
Because
I'll do it. Anytime convenient to your lordships, I will do it, my lord.
Mr. Kohli is there. Mr. Jamil,
So,
we choose the next date, Mr. Datta. We'll take it up next Tuesday. Tuesday, Wednesday, 2 days.
No problem.
What is the date? Tuesday, Wednesday? What's the date?
Lord, so far, my lord, the question of Article 371A, my learned friend has very exhaustively and expressively
25th, 26th.
expressed the entire gamut of 371A. So, my lord, I will, if your lordships permit me, I will just try to, my lord, add something.
But that's why
That's
I'll give 2 days so that
Yes.
it can be sorted.
I'll take hardly half an hour.
It's 25th, 26th, my lord.
Just a moment.
26th, 27th, it's Monday and Tuesday. Or any day thereafter, subject to your lordship.
27 will suit me also, lordship.
28th, 29th,
28, one shot,
which one?
one shot.
That's all.
27th then?
I think Mr. Jamir is
He's suggesting
okay.
27th,
27 and 28.
27, 28.
Well, say from 26, that will be ideal, convenient from you also, lordships.
26 is
No, Monday is again motion day, so that
27 and 28. We can.
27, 28.
28 will suit
I'm
fine.
grateful.
Okay.
27 and 20, yes.
Both sides. You'll have the name of the learned council. Huh? I'm just dictating the operative part. The submissions of Mr. K. N. Balgopal, Learned Advocate General, assisted by Ms. M. Keshi, Learned Additional Advocate General, remains inconclusive. Expera is agreed to by all sides. List the matter on 2 consecutive dates on 2 consecutive dates on 27/5/2025.
My lords, I'm speaking on behalf of Mr. Vivek Kohli, who's on his legs before NCLT. Just wanted to request that he will be in full day arbitration starting from 19th May. So on 27th, 20th, or 26th, the learned AG may conclude his arguments, but Mr. Vivek Kohli will be able to conclude his arguments only after May.
Let us see, let us have the 2 days first.
27,
Then we'll
28.
see. And 28.
So 27, 28 would be difficult for him. That's what I wanted to inform.
It's okay. It's okay. Somebody can be there.
Yes, somebody can be there on his behalf, but he may not make himself available.
Okay.
Okay. Thank you very much.
May it please the lordship.
Judgment. Pronouncement of judgment oblique order. Supplementary item 90. WBC 5564 oblique 2018.
The matter is remanded back for a first decision to the learned tribunal. The petitioner is directed to appear before the tribunal on or before 13/6/2025 without any requirement of a notice being served. Registry should send back the records.
Highly obliged.
Pronouncement of judgment item 91. Writ appeal 48 oblique 2025.
The appeal is dismissed. However, before parting with the records, we make it clear that nothing contained in this order will prejudice the parties herein in the event the appellants assail any notification or order passed by the respondent authorities or take action or any action taken during the pendency of the connected writ petition and or review petition, as the appellants may be so advised.
May it please the lordship. Lordship, I'd like to mention item number 10. The engaged counsel had to leave the court for some urgency. So kindly the matter may be taken day after tomorrow, your lordship.
Just wait for some time. Let the matter be, we'll see the record and then.
Next.
Lordship, I'm praying for calling for the records of additional affidavit that is in file with regard to item number 3 and 4.
Okay, give the requisition.
Much obliged.
Lordship, I beg to mention item number 17. I have some personal difficulties today, so the matter may come up after 10 days, Lordship.
17.
Yes.
Okay, both sides are represented. This after 2 weeks, as paid for bail and cost for the petitioner. Okay.
Acknowledged.
May please, your lordship. I was to mention item number 38 for arbitration matter.
38.
38. This for correction of order.
Okay.
May please, I beg to mention item number 93, lordship. Matter may be upgrade, lordship. Petitioner is jail hazard case. 93. Supplementary. Yes, supplementary.
Okay.
Applies.
Please, lordship, I like to mention item number 31. Kindly this matter be adjourned for today.
31.
Yes.
You're praying for an adjournment. Okay, 2 weeks. 31.
May I please, your lordship, with the consent of the addressor, I beg to mention item 21. It may be passed over for the date.
21.
Yes, your lordship.
Okay.
It
It goes after 2 weeks.
May I please, your lordship, I beg to mention item number 27 and 32, lordship. Lordship may not like to take up this matter.
Okay, 27 and
32, lordship.
32.
Yes, lord.
Okay, 27 and 32. List the matter before any of the bench without one of us. Very cares for Anaji. Okay.
Please, lordship, I beg to mention item number 7 and 8. Lordship, my learned friend P. Bholdras is not well and is not able to attend the court today.
7 and 8 in motion matters, just wait for the matter to be called. We will consider a pair then.
Lordship.
May I please, your lordship, I beg to mention for item number 12 and 37. After 2 weeks.
12 and 37. Use item 12.
Suppose.
Yeah.
Item 12, please check the cause list.
Yes.
Since you are appearing, can we strike out the name of second counsel for the respondent?
Yes, no.
Huh? Okay. All sides are represented. The prayer made by learned counsel for the petitioner, the matter is adjourned today. Next para. As Mr. A.I. Ali, learned standing counsel for the ECI is appearing in the matter. The registry shall delete the name of Mr. D. Barwa, learned Mr. D. Barwa as counsel for the ECI while listing the matter next. Next list after 2 weeks.
May I please, your lordship?
That is in 2 weeks.
May I please, your lordship?
Hmm.
I beg to mention for item number 24. I pay for it.
Oh, just a moment, item 37. No, no, yes, yes, that's okay. Ready to cure करना चाहिए. Yes, item number
24.
24.
24.
24. You want an adjournment?
Yes.
Okay, 2 weeks.
I will write an internal order that we will continue.
Tomorrow past few stands extended till the next date of this.
Obvious, 24.
Was there in item 37? Not here. Just make it next Monday.
Next.
Daily list item 1 for motion.
So in the instant matter, the petitioner has come with the grievances that petitioner was first in Annexure 2 is the order of the Foreigners Tribunal. He has been declared as a foreigner, Your Lordship. So against this order, he filed a writ petition before this honorable court, that is that is Annexure 13, page 45, whereby this honorable court interpreted the order, directing him that he is a citizen, Your Lordship. So accordingly, he has filed a representation before the election commission. So he was saying that that DA should be removed. So since that was not removed, he has filed his instant writ petition. So I have obtained my instruction. As per instruction, steps have been taken, Your Lordship. And accordingly, when the next summary, after summary revision, when the electoral roll will be published, his name, D will be removed from his name. Your Lordship. There was some delay, Your Lordship, because earlier his name was in a different constituency. After delimitation, his name has come to 7 Gauripur LAC. Earlier it was in 26 Bilasipara West LAC. So because of this delimitation exercise, certain delay has been caused in this matter.
A.I. Ali, Leonard, Standing Counsel for the Election Commission of India, has submitted that pursuant to the order dated 2/8/2021, passed by this court in WPC 716 of 2021, the Election Commission of India has taken steps for removal of inverted commas D, inverted comma closed, mark in respect of the petitioner, comma, namely, comma, Soleiman, Soleiman, Fakir. And the same will be reflected after the final publication of E-roll, E capital, E-roll 2026, after the upcoming summary revision as a regular voter. Next para. The Learned Standing Counsel for the Election Commission of India is for this submitted that as per written instructions dated 14/5/2025, comma, received by him, comma, prior to the current exercise of delimitation, the name of the petitioner was listed under 26 Bilasipara West LAC, and subsequent to the delimitation process, the name of the petitioner has been included under number 7 Gauripur LAC. it is submitted that due to the said process, some delay has occurred. Next para. A copy of instructions dated 14/5/2025. You just say the letter number, communication number DEL, full stop 13/2025, dated 14/5/2025, addressed to the Learned Standing Council for the Election Commission of India by the election officer, Dhubri, is made a part of record. Next para. Under the circumstances, no live issue remains in the present writ petition. Full stop. Next para accordingly, in view of the contents of the hearing before referred communication dated 14/5/2025, issued by the election officer, Dhubri, which is made a part of record, this writ petition is closed. However, with a direction to the election officer, Dhubri, to do the needful in terms of his communication or removal of inverted commas, D inverted comma closed mark in respect of the petitioner, namely, Soliman Fakir. During the final publication of electoral roll of the year 2026.
Item 2 for motion.
May I please, Lordship? Page number 90, my lord, 90.
90.
Lordship.
You've done the corrections?
Lordship.
You're challenging a 2023 order.
Yes, Lordship.
You'll call for the records.
Record is already received.
Records have come. Okay.
Filed on 18/9/2024.
Okay. What is the best document you have to connect you with your projected parents?
One on Zomamundi copy, my lord. This is page number.
Which page?
31.
31.
Lordship.
Which is your relevant entry?
Order dated, my lord, 29/6/2018.
29.
6/2018.
Page number 35 in the vernacular.
Side 35.
But there's a difficulty when you are showing us this page 31. The name of your father was mutated as a purchaser in 7/11/1988. That is post 25/371 document.
My father's name is appeared in voter register plan in 66 and 70.
1966
and 70.
Where is that? Which page?
Page 21. Okay, 21 and 23. Serial number 339.
Page number?
Serial number 339.
Page number?
21. Voter list of 66.
Something is wrong. Something is wrong. You're showing us page 22. Correct.
Lordship.
What is the name of the first person?
Muqsid Ali.
No, first name in page 22.
Saudagar Ali.
Sadagar Ali. His father's name is?
Romesh.
Romesh. Come to page 31.
Yes, his father's name is appear as Nomizuddin.
Then?
Lordship. And other, the Saudagar is there, my lord. Akbar Ali is also there. Muqsid Ali is also
No,
there.
we understand, but you see Akbar Mia again Romesh.
Aye.
Muqsid Ali is Romesh.
Lordship.
Now here you are saying that your Muqsid Ali is son of Nomizuddin. That can't be a typographical error.
And in page number 28 also, my lord, in voter list of 1997, which is exhibit.
But 1997 is post 25/371 document. How can you connect yourself with 1966 and 70?
And his grandfather is written as Nomesh in 1997.
And in fact, you don't have a case.
And my elder brother also deposed my lord as
Who is your elder brother who came and deposed?
Shahjahan Ali. My lord. My lord, his name appeared along with my parents, my lord, in 1989 as page number 25.
You see, you see this name of you know, something is horribly wrong. You're not getting 1 plus 1 to 2. Come to page 54. This is your evidence, Noor Nahar. It starts from page 53. Come to paragraph 7. 6 and 7. 6 says your father's name appeared in the voter list of 1997. Next paragraph 7, you say, after 97, my father expired. Correct. Now come to this Jamabandi at page 31. That means this mutation occurred before your father expired. Come to page 31, your English typed copy. Gha. As per order dated 2597, so and so, Shahjahan Ali is number 3. All have been mutated as inheritance in place of Patada number 1. Pata number 1 is Sadagar.
Shahjahan Ali Malad, this is the another Shahjahan Malad.
Then which is your
And
who
page
is
number
your Sadagar?
32, Page number 32, Malad.
Page number 32.
As per order dated 29/6/2018.
If it is 2018, then again there's a reasonable doubt. Here, the police reference is of 2015. Your father died in 97. The mutation comes after this with all that.
Last Mandal was also examined. But
Can we ask you, what is the education qualification of this Shahjahan? Your DW 3 or 4, whoever he is, your brother? Are you aware? No.
no, I have to take the instruction.
You have read his deposition, I believe. No. He says very interestingly that I did not attend my sister's marriage. I was studying in school. That's why we are compelled to ask if he is such so studious a person not to attend sister's marriage because of school education. Can there be a brother who doesn't attend sister's marriage? Then
The land document, my lord, was proved by the Last Mandal.
it is not accepting the land documents. The difficulty is accepting the entries made therein. All the entries come after you see your father, according to you. Although there is a doubt whether the person projected is your father or not, because all others are son of different parents. As per the Jamabandi and the voter list, it doesn't tally. That apart, your father died in 1997 and the mutation entries are 2018. When the reference started in the year 2015, that means these are post-reference created documents. That is the difficulty. That's why we were compelled to read the evidence. Not in all cases we read this evidence. What is your first voters list where your name was entered?
My lord, the petitioner entered in 1997.
1997 is the first voter
Lordship.
list. Please show us that voter list.
That is not available, my lord.
It's not there.
No.
You come to page 55. This is your evidence. 1997 voter list contains the name of your father-in-law and husband. Where is your name? So apart from the linkage certificate from the Gaonbura or others, where is the evidence of your Gaonbura?
My lord, page number 59. '59.
Pardon me, which page?
59.
59. He is a Gaonbura of which charge? Morigaon and Moripam.
Morigaon and Moripam.
Do you have a copy of this exhibit H with you? Exhibit P. Do you have a copy of that with you?
No, my lord. Yeah. In the report, maybe. It is in the record.
Who is exhibited exhibit P?
Population register. This is Gaonbura.
And can you show us that page where this exhibit is mentioned? Exhibit P is by whom? Page 65 says Gaonbura.
This is of village Tedera Patha. Tedera. Husband's village man. He is exhibited P, my lord. The population register.
Which page is your written statement?
Statement number is number 48.
You're giving him bail. Mr. Pine, you're giving him bail. Let Mr. R. Ali, the counsel for the petitioner.
HM.
I'm sorry, H.A. Ahmed, then counsel for the petitioner. Respondents are there, and Ms. P. Barwa for the ECI. Page 90 is the opinion. dated nine six 23, passed by so and so, so and so. You should notice extra copies within 2 days. Pursuant to order dated 25/9/2024, the records of the tribunal is received. Next, prayer for bail made by the learned counsel for the petitioner is opposed by the learned standing counsel for the FT matters. As the perusal of the record would take some time. Not notice, make it issue rule. No, make it. Next part. Considering the projection made in this repetition, what is inclined to grant bail. 10 days time to take bail of rupees 5,000 to the satisfaction of superintendent of police border, Borpeta. Next point. This is the matter for hearing in the month of June 2025.
Thomas.
Item 3 for Moson.
Made please. My lord, the opinion is at page 88.
Your first voter list is 2005. Which page is that?
My lord, at page, my lord, 78, my lord. My lord, that voter list with along with my lord husband. It is exhibit D, man, page 78. Same village, my lord, Saralpara, Hastinapur, Moja, my lord. Jamaluddin is my husband, my lord, and Surujun Nasan.
Any document connecting to your parents?
My lord, I have, my lord, file 1965 voter list. My parents' name are Ramjan and Rubjan, my lord, which is at page, my lord, 44, my lord. And thereafter, my lord, I also filed a voter list of 1970 of same parents, my lord. And thereafter, my lord, I filed one voter list of
No,
1989.
no, not voter list. Your name does not appear with your parents.
Yes, my lord.
There's some other document which connects you
Yes,
to
my
your parents.
school certificate, my lord, at page 71.
71.
72 is the, my lord, vernacular, man. প্রমাণপত্র দেওয়া হল যে মিস সুরুজান নেসা, পিতা রমজান আলী, রূপজান নেসা, গাঁও সারালপাড়া, ডাক ভকুৱামাৰী, থানা পাটাচাৰকুছি, জিলা বৰপেটা, অসম। উক্ত ছোৱালীজনী বৰ্তমান মোৰ স্কুলত 1989 চনৰ ৩য় শ্ৰেণীত অধ্যয়ন কৰি আছিল। ভৰ্তি মতে বহিমতে তাইৰ জন্ম তাৰিখ 1/1/1981 চন। মই তাইৰ ভৱিষ্যত উজ্জ্বল ভৱিষ্যত কামনা কৰিলো। Sadek Ali Ahmed, he was deposed, my lord, as PW3, my lord, page 16.
Who is he?
He is the, my lord, headmaster of that school.
Which page is his deposition?
Deposition at page, my lord, 68. Annexure 11.
But this was disbelieved because it contains several entries and incorrect entries and overwritings.
Only by, my lord, the name of the mother was not in the original admission register.
No, in the opinions, some adverse comments are given in the school's register, saying that unauthorized entries are there, overwritings are there.
My lord, if your lordship, my lord, go through the, my lord, certificate, my lord, at page 71, my lord. The certificate, my lord.
No, I have read somewhere, it
Yes,
says,
my lord, in the opinion, my lord, it was, my lord, reflected.
it says so because you see that's why we asked you to show this evidence at page 68, you are referring to it. 69 is the handwritten copy.
Original copy.
Here, he says admission register name of mother is not mentioned. In the name of student, one alphabet is missing. In torn condition, there are overwriting on the date of admission. As told by her mother, name has been mentioned in the
Yes.
certificate. So as told by her mother,
Mother name has been
has
entered, my
been
lord.
mentioned in the certificate. So therefore, entries which is not there in this school register, finds entry here in this certificate. So the certificate is not in accordance with the admission register.
Only, my lord, the mother name is not there. On the instruction of the, my lord, my lord, the petition, it was entered.
See the last line of the cross-examination. I mentioned the village as Charal Para, but the admission register reveals the name as Paschim
Right.
Karaikhwa.
It's
So
a,
everything is changed.
it's a, my lord, adjacent, my lord, village.
No, that we don't know.
That is, my lord, come out in,
Ujan Bazar may not be same as Pan Bazar.
my lord, Gaubura also, my lord, given one certificate, my lord, at page 76.
Page
Page 76, my lord. Certificate of Gaubura. 77 is the, my lord,
just a moment. Gabra is DW.
my lord, Gaubura is DW4, my lord.
Page number
Page number, my lord, vernacular is page 77, my lord.
77.
Certificate, my.
No, his evidence is
Evidence at page 73.
70.
3. And original one is at 74.
If that be the case, then there is no error in the opinion,
My lord,
even for issuance of notice. Your own documents show that your parents were living in village Dolor Pathar. That is voter list of 1965. So either this person is your father, or what OP4 says, there should be somebody else who is your father. Your father says that she was born in village Choralpara. 65 voter list is of Dolor Pathar.
in my lord WS, in my pleadings, my lord, I have especially mentioned, my lord, that they have shifted, my lord, from Dolarpatha to Saralpara in the year, my lord, 1980, my lord. Thereafter, I was born in the year 1981.
Where is that statement?
That statement, my lord, is at page 25, my lord. 25 and 20, 25 is, my lord, in the last 5 line, my lord, that the father of the proceedee along with family shifted their residence from village Dolarpatha to nearby village Soralpara in the year 1980. In the below part. And at page 23, my lord. Para 4, my lord.
Yes.
That the real fact is that the second party was born in the year 1981 at the house of her parents at village Saralpara. After coming from, my lord, from Dolarpatha, my lord, the proceedee was born.
Okay.
And my lord, she is suffering from cancer also. I have annexed, my lord, some documents.
Where is that?
That, my lord, 108, my lord, page 108. medical document start from page, my lord, 102 and in 108, my lord. Impression chronic myeloid leukemia, chronic phase. My lord.
Mr. Pine, we give a bail then. Okay. Let's send Sarkar and counsel for the petitioner. Respondents are there, Sir Ali, Mr. Sharma and Mr. H.K. Hazarika. Then dated 22/12/2023, past page 88. Reference case number is 83 of 2014. That is at page 89. Notice, call for the records. Extra copies within 2 days. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that petitioner has failed to establish his link with his projected father and to show that she is a Indian citizen by birth. Next paragraph. Considering the projection made in this writ petition and further considering the further projection made in this writ petition that the petitioner is suffering from chronic myeloid, myeloid, leukemia, leukaemia dash chronic phase. As per the blood examination report annexed to this writ petition, court is inclined to grant bail to the petitioner. 10 days time to take bail of rupees 5,000 to the satisfaction of SP border.
Borpeta, my.
Borpeta. Okay.
Much obliged.
Colleagues.
Item 4.
Wait, please, Your Worship. My lord, opinion is at page 38, my lord. In this case, my lord, the mother's name appeared in the voter list of 1965, my lord, and 1979. And my lord, mother also deposed, my lord, before the court as a DW2, my lord. Her age is, my lord, 90 years. Opinion is page, my lord, 38.
We'll call for the records here. We are not inclined to grant bail at this stage. In this case, we are not granting bail. We are calling for the records. But Mr. N. Sarkar, land counsel for the petitioner. All the respondents are there. Opinion dated 4/3/2023. Passed by so-and-so in so-and-so. Reference case number is at page 39. Opinion is at page 38. Reference case number 80 of 2014. Notice call for the records. Extra copies within 2 days, call for the records. Give a date after 4 weeks. That the period for bail for the petition shall be considered on receipt of tribunal's records. List on so-and-so.
16th
My
of
lord,
June.
meanwhile, she may not be deported.
In the meanwhile, if the petition is apprehended, she shall not be deported out of the country without order of the court. Okay, she's not arrested.
No. Much of.
Item 5 for motion.
No representation from the petitioner. It is seen that the petitioner was unrepresented when the matter was previously called on 5/3/2025. On 9/4/2025, the land counsel for the petitioner prayed for some time to file additional affidavit, which was allowed. So today, petitioner remains unrepresented when the matter was called. Next list on. Make it next Friday. List on 23. 5/2025. So if the petitioner, if the default continues, the inverse orders will be passed.
Item 6.
I believe, Your Lord.
Yes.
Contested case, Your Lordship, the petitioner is declared to be foreigners. I know this, in this case, at page 26, Your Lordship,
Where's the opinion? Which page?
there's 41 onwards, Your Lordship. Petitioner's father's name is recorded, found to be recorded in the 1966 voter list. Then in the 1970 voter list.
Where is the voter list of 1985?
1985 built. Page 28, Your Lordship. Twenty-nine is the vernacular, Your Lordship. Fojit Ali is the petitioner, Your Lordship. Against his name, his father's name is recorded as Muhammad Ali.
There's something wrong. The figures don't just add up. In your affidavit in this writ petition, which was filed in 2025, your age is shown to be 63 years.
And
If it is 63, then you'll be 1962 born. In your 1985 voter list, you are 29 years. It does not match.
But erroneously recorded in the voter list. But in most of the voter list.
Voter
my
list
lord,
can't be erroneous. You have not challenged it. It's in your written statement, you have not explained that.
My lord. There is some mistake on the part of the procedure, lordship. Some voter list was not exhibited, my lord.
He has filed it within a year. This writ petition was filed on 6/2, sorry, 7/2. Within a year, we give him bail then. What is your relationship with DW2?
DW2 is the uncle of the petitioner, your lord.
It is good to have uncles like this.
My lord.
These are finally granted bail. This come within a year.
My lord.
Your uncle is a good witness. He knows how to depose, but he does not know what to depose.
My lord, illiterate person, my lord. They are very illiterate, my lord. This petitioner also, he also cannot answer some simple question also. Illiterate person, my lord. And in the tribunal, my lord, some voter list could not be exhibited. The
But
petitioner-
we don't find a case.
petitioner is
Your
saying
only
that-
good point is that you have come within a year, you are getting a bail. There's nothing here. You're not getting anything.
May I pray one thing, my lord? Let the matter be remand back for.
Remand without hearing you.
My lord, for today's decision, your lordship.
First
Some-
of all, for that, you'll have to be ready for hearing.
Some vital documents
We'll
could not
take
be
it up.
annexed, could not be
We'll
executed.
take it up tomorrow for hearing then.
Sorry.
If we have to remand, we have to hear. Do we take it up for hearing, final disposal tomorrow?
My submission is that, my lord, actually.
No, your
youngest-
submission is okay, but I have to hear you for remand. Because in the order I'll say I've heard. Do we fix it up for hearing tomorrow
No,
at the
my
motion
lord.
stage? If you are prepared, we'll take it up tomorrow.
I have some liberty tomorrow, my lord. But some other day.
Then you choose your date when you want it to be heard. Choose a date from the calendar. Whenever you want it to be heard, we'll take it up on that day.
No, if your lordship is calling for record LCR,
No, it is your submission. We accept your submission. Are you agreed by that?
up to your lordship, lord.
Tell us the date.
Up to your lordship. LCR may be called for.
No, you see, I don't want to antagonize you at the bar. I was giving you bail, but you said that no, you remand the matter. For that, we'll have to hear you. Now you choose the date of hearing.
I thought I could not annex the cross court also. LCR will be required, I think.
Okay, heard. So A. Rahman, counsel for the petitioner. Respondents are there. Opinion dated 28/3/2024, page 41, passed by so and so and so and so. Notice extra copies in the 2 days, call for the records. Therefore, bail is opposed by the standing counsel for the FT matters on the ground that the petitioner has failed to show that he is an Indian citizen, and moreover, the DW2 examined by the petitioner has not been able to prove the linkage between the petitioner and his projected father. Next one, either as it may, in view of the projection made in this petition. 10 days time to take bail of this 5,000 to the satisfaction of SP border. Oh, no,
Walpur.
you still don't get an order. Your respond number 6 is incorrect. Make the correction and then come again.
My 60.
District. Nomenclature of respond number 6 is incorrect, so the petitioner shall correct the same by submitting a freshly typed out first title to the AOJ civil, FT section, and thereafter the matter will be listed again in the motion column. Make the correction. Respond number 6 is wrong.
District. Right. Must have lost.
Item 7.
Item 7 for motion.
No representation from the petitioner. So all the respondents are represented. As the next para, as the petitioner is asserting the opinion dated 29/2018. Then counsel for the petitioner shall make his submissions on the issue of maintainability of this petition on the ground of delay and latches. Next para. Just after a week on a date to be fixed by the registry. Item 8.
Same group of lawyers.
Hmm?
Same group of lawyers.
Same order. Here also 2000, the old opinion is wrestled here also.
Yes.
Item 9.
This is a lordship. It is impugn ex parte order dated 9/1/2023. Have preferred this petition, my lord. What happened, we received notice, my lord, but instead of approaching the honorable learned tribunal below, we approached the Gaobura, my lord. As a police,
Let us call for the records and to consider your prayer for bail on the next date.
in fact, IMDT Nalbari declared me as a citizen of India, my. I have annexed it,
Which is that page?
page 40, your lordship.
40.
Last but one paragraph, your lordship, last 4 lines. As the plea of the OP that he is an Indian citizen by birth must be and is upheld, the allegation therefore that the OP is an illegal migrant under the Act is without any basis. Accordingly, this reference is answered in favor of the OP against the state. And it was held that your lordship, OP's father was a resident of village Garoghoto, PS Tambulpur, since 1964, which is much prior to the material date, my. And he's proved to be a lawful citizen of India.
Will be, Mr. Payam, holding this records of this case, page 40, will be holding it,
This record, my lord.
IMDT case.
Yes. This will be very difficult to find out, my lord. It will be generally lying, if it is record is available, my lord, it will be lying in the FT first Nalbari.
FT first.
Yes. Because only matters, my lord, of but district of IMDT, those are kept in the FT first.
Ms. B. Bharan, Senior Counsel, assisted by Ms.
R. Das, my.
R. Das, from Counsel for the petitioner. Also heard respondents are there, Mr. M. Islam. The ex parte opinion dated 9/1/2023 passed by the London member, Foreigners Tribunal, Buxa. That is page number
Page number 17 to 20, your lordship.
page number 17-18. Order 9/1/23 opening. Especially in this petition, an Article 226 of the Constitution of India. Next, the Senior Counsel for the petitioner has referred to Annexure 7 to this rate petition. Project that the petitioner was declared to be a Indian national by the then IM within bracket D, bracket close T, Nalbari, by an opinion dated 23/2/1989, passed in case number IMDT within bracket NAL, bracket closed, 196 of 88, bearing reference number 17 of 1986, page 40. Issue of this returnable on, give a fixed returnable date after 4 weeks. Returnable on so and so. Extra copies of the date should be served on the within 2 days. Next para. The registry shall call for the records of page 17, FT case number so and so, as well as page 40, IMDT case number so and so. From the learned member, comma, Furnace Tribunal, first Nalbari. Next, apart from usual. Not apart, is the requisition shall be sent to the following email address of the set to tribunals. Next file. Prayer for bill shall be considered on receipt of the records of the tribunal.
16 June.
But with regard to this document, is 40. But I'm just submitting that, but it may be there, but it is not confirmed that it will be there available.
No, we understand.
Yes,
We understand. It'll be too old.
yes, it's true.
We understand, but let me send a report.
Item 10.
Please, Your Lordship. We are
Just
praying for petition.
You had made a prayer for adjournment. Ah, yes. Also is represented Mr.
Yes, Raja, my Lord.
P.S. Raja, Commander and Counsel for the petitioner prays for adjournment. Next paragraph. Taking notice of the fact that ex parte opinion dated 19/6/2018 is assailed in this writ petition, comma, on the next date of listing, comma, the learned counsel for the petitioner shall address the court on the maintainability of the writ petition on the ground of delay and laches. Next paragraph, list on. When do you want?
Lordship, as per your convenience. Only today we have inconvenience.
Pardon me?
Only today we have inconvenience. Lordship, convenience.
post it only.
I'm not getting, we can fix it any day. Okay. Day after tomorrow? Okay.
Hello, please.
Supply item 92.
Yes.
Discrepancy in spelling of the name of the petitioner.
Yes.
Spelling mistake, some minor.
Pardon me?
38 or 90.
Spelling mistake is there.
We understand, but with that spelling mistake, we can't do anything. You tell us what to do.
Amended post title I will submit, Lordship.
Okay. Your name?
M. Rahman.
Mr. M. Rahman and counsel for the petitioner. Praise for and is granted liberty to amend the cause title in respect of the name of the petitioner, comma, which shall be done by submitting a freshly typed up cause title to the AOJ civil, FT section. Thereafter, the matter be listed before the court. Full stop. Just add there, by submitting a copy to the AOJ, along with copies thereof to the learned CGC, comma, State and Departmental Council. Give copies to them also. Next paragraph, all the respondents are represented. The matter be listed in the motion column after the corrections are made.
Upgraded item 38 for orders.
May I please? This is earlier bail was granted directing the petitioner to approach before the SP Borpeta for obtaining bail, my lord. On 26, last 26, he appeared before the SP Borpeta and SP Borpeta said that the case record is transferred to the SP Baksha as the residence of the petitioner now fall under SP
Mr.
Baksha.
Pai?
So I may be allowed to amend the first title of the writ petition, my lord, regarding respondent number 5 and 6 and
Okay.
address of the petition.
Heard Mr. H. Ahmed and counsel for the applicant. Respondents are there, Ms. P. Barwa. Next part. Filing this interlocutory application, comma, the applicant, who is the petitioner in WPC 2166 or 2025, has prayed for permitting the applicant to amend the cause title of the writ petition insofar as respondent numbers 5 and 6 are concerned. Next para.
And address of the petitioner also. And address of the petitioner also.
Okay, as well as the address of the petitioner. Next para. Referring to the statements made in this interrogatory application, comma, the learned counsel for the applicant has submitted that having obtained bail by order of the court dated 25/4/2025, passed in the connected writ petition, comma, when the, sorry, it will be applicant here. everywhere right applicant. The applicant appeared before the Superintendent of Police within bracket border, bracket was Borpeta. But she was informed that the records have been transferred to the jurisdictional Superintendent of Police within bracket border, bracket was Baksa, as the residence of the petitioner falls within the said district. Stop. Next para. Heard the learned standing counsel for the FT matters. Next para, considering the submission made, the prayer made in this interlocutory application for amendment stands allowed. Next para, the applicant is permitted to amend the cost title in respect of the address of the petitioner, sorry, applicant, as well as the to amend the cost title in respect of the respondent numbers 5 and 6 by substituting the said authorities of District Borpeta to District Baksa. Next, this application stands disposed of.
I may be allowed to approach the SP Baksha within the next 10 days. Earlier 10 days was given.
Okay. Such corrections shall be done. Within 2 working days. Next para, subject to amendment of the cost title. Oh no, this will be closed. Just close this here. The other order will be in the writ petition. Next para, this WBC 2166. So and so. Next para, by an order passed today in the connected IAC Bill 1379 of 2025, the petitioner hearing is permitted to amend the cost title in respect of the address of the petitioner as well as the designation. No, sorry, the district of the authorities arrayed as respondent numbers 5 and 6 by submitting an amended cost title to the AOJ FT section for being incorporated in the writ petition. It shall be done within 15/5/2025. Next para, subject to amendment of the cost title. The court is inclined to provide that in the event the petitioner, namely so and so, appears before the Superintendent of Border within bracket, Superintendent of Police within bracket border, it was Baksa, within 10 days from the date of the order, the said authority shall do the needful in terms of directions for bail contained in paragraph 6, 7 and 8 of the order dated 25/4/2025 passed in this writ petition. Next para, it is clarified that the said directions were issued upon the Superintendent of Police within bracket border, bracket close Borpeta. It shall now be treated as directions to the Superintendent of Police within bracket border, bracket to Baksa. Next para, list after 2 weeks, awaiting receipt or records of the tribunal.
I had disposal. I may be disposal.
Upgraded item 93 for admission.
May I plead your lordship? Lordship, petitioner already declared as an Indian but opinion dated 25/1/2011. But the petitioner is completely unaware about the register of the present case FT 130617. Lordship, moreover, in the notice, the name of the person concerned recorded as Mafia Rahman, and in the reference case name of the person concerned was recorded as Motiur Rahman. Lordship.
This matter, my lord, if your lordship permits.
You've seen the records?
My lord, I have gone through, but it takes some more time, my lord. Can it come in the next week, my lord?
Lordship, petition.
She's in jail since 12/12/2024. That's why we adjourned the matter on the last occasion. We gave the records to.
Who, my lord? If possible.
She's in jail since 12/12/2024.
Let it be listed tomorrow, my lord.
Tomorrow.
Yes, I'll set it up.
Lordship, petitioner behind the bar last 145 days.
We are aware of it. That's why when I say 12/12, that means I have read that.
Lordship, 2012. Wrongly written is 12.
It is 2012.
2012.
Okay.
Let it come on tomorrow, my lord.
Okay. On the, which is represented on the prayer made by Mr. J. Panek, Learned Standing Counsel for the FT matters. List on, make it tomorrow, 15/5/2025. Send it by slip.
Yes.
Send it by slip. We get it listed tomorrow. Okay.
Item 11 for admission.
Yes.
Well, in this case, on the last occasion, the government was directed to take instructions regarding the verification of the ID card as pursuant to the order dated 11/4/2023. 11/4/2023. The last order 34/25.
But page 18, the LCR is not, it doesn't have identity card.
Identity card, my lord.
Page 18.
Page 18 of the read petition, it is, perhaps it is only oversight written in the LCR, my lord.
Oh, acha. Page 18.
Page 18. The read petition. Annexure A. I have served the copy to the Mr. Sharma, my lord, on that date, last day, occasion.
Mr. Ayang, there will be one difficulty. You'll have to first ascertain who which is the authority will have this document?
Yes, madam.
Because this is RR branch,
Yes.
page 18 of the writ petition. RR branch means relief and rehabilitation branch. But this was discontinued after, I forgot,
Yes.
77, 78 somewhere.
Down below it is, my lord, yes, down below it is FAC public inserts transit cam Karimganj. Let us verify, my lord, where is this document, if possible.
No, I think for that, the matter was adjourned.
Yes,
Even last occasion, it was adjourned
yes, ma'am,
for that reason only.
yes. Let, my lord, your lordship may grant another 2 weeks time, my lord, we are trying to get the information.
Because last time we checked up. In fact, this I forgot what I saw. Whether this will be here or it will go to the central government. Some central government authority will be having it.
Yes.
Last time, what did I say when I checked it up in the net? What did I say?
My lord,
About this rehabilitation branch, what did I say last time when I made the check at the internet? I think I shared something with Mr. Sharma. Just find it out from him.
yes. I'll take the instruction, my lord. Probably it is the central government who may have anything, my lord.
No, we don't know. State government, this rehabilitation branch was earlier with the state government. Because at that time, the relief and rehabilitation of people who have migrated from Pakistan and East Pakistan, that was being undertaken by the said authority. Because when it came to rehabilitation, it was for the state government to rehabilitate. At that time, we got, in some other matters we have seen, somebody has been given a loan of rupees 1,000, somebody has been given loan of 2,000 to settle. So it is only you who can tell us.
So, my lord, let me get the instruction, my lord. We have already sent a letter, my lord. So
Okay.
we are not getting the information, my lord. Another 2 weeks may be granted.
You know the word pest. You have to
Yes.
pester them. Okay. Mr. PC Data and Counsel for the petitioner is present. Mr. J. Payanglan is standing counsel for the FT matters. Prays for further 2 weeks time to obtain instructions regarding the identity card which is annexed to this writ petition as annexure. This is annexure?
A, my lord.
Annexure A at page 18. Which was issued in the name of Birendra, Birendra, Kumar, KR, Mr. Roy, ROY, bearing identity card number 4050, issued in the stationery of Office of the Sub-Divisional Officer, Karimganj, RR branch, which is signed by the issuing officer as well as by the EAC. There will be full stop, E full stop, A full stop, C full stop, comma, in charge, comma, transit camp Karimganj. dated 23/5/1964. A copy of which has already been handed over to Mr. G. Sharma, the next standing counsel for the FT matters on 34/2025. Next para. The learned standing counsel for the FT matters is permitted to send a downloaded copy of this order to the concerned authorities to track out as to who will be the custodian of the said records of the said identity card, as well as to give instructions as to whether the said document annexed at page 18 of the writ petition is a genuine document in terms of order dated 11/4/2023, passed by this court. Next para list on, give a fixed date after 2 weeks.
My lord, 30 May. My lord, in the month of June, first week of June, my lord.
Okay. 2nd June.
Item 13 for admission.
May please, My lord, opinion part is page 24 kindly, dated for 12/4/17. My lord, in this case, what happened? I was, in spite of all the documents, I was declared 671 stream. Then I submitted a review petition enclosing my birth certificate, man, where my father's name is there. But learned member has rejected. Then I approached the Foreigners Tribunal immediately after the judgment of the review petition. But Foreigners Tribunal has not accepted my application for entering my name, my lord. So my grievance is that now I have all of 8 years already completed, my lord. I want to register my name, my lord. In spite of the fact that I have got all the documents, my lord.
But then you are in a difficult spot after this judgment in the in this reference case
6 ML.
of 6A.
Yes.
Then the court, nobody will have jurisdiction to have you registered.
I have approached before your lordship for that in 2007, this case was 2018, my lord.
Have you checked up its judgment in the 6A case? There is a specific bar now.
But my application was within 180 days.
Registration.
From which document you are showing so?
My lord, there is a letter, my lord, that I submitted before FT, my lord. That is page 29. Dated 9/7/18.
This FRRO, Mr. Payang, is under Home Department.
Yes.
Then the registration in the last case,
Yes.
the registering authority would be FRRO then.
Yes. Registering will be, my lord, FRRO.
No.
For it. In
In
that,
the last case, we were referring to this RR branch,
yes, ma'am.
rehabilitation and
Yes.
resettlement branch. Then this document may be with the
FRRO also.
FRRO also.
Let me check it out, my lord.
Mhm.
Yes.
Where is the order passed in the review petition?
Review petition order is made at page 27, madam.
Which is that provision for registration?
Constitution 6A, madam. 6A.
Citizens.
So here it would be 60 days. Under 6B. 6B says any person referred to in subsection 3 submits the prescribed manner form, the prescribed authority within 60 days from the commencement of Citizenship Amendment Act. Because you see, we are asking you to address us on issue. You see, we have interpreted the issue of limitation, which a specified act prescribes. In light of section 29 of the Limitation Act, 29 says that the limitation prescribed in the other acts prevail. Therefore, if under the Citizenship Act, there is no order to empowering to extend the period of limitation, section 29 creates a legal bar. We cannot extend the time. That is one part. Corollary is that when an opinion was rendered, after that you file a review petition.
Yes.
Review petition itself is not covered by the situation of section 14, where you say that the this time spent bona fide in the court without jurisdiction. Because otherwise also 29 would exclude 14. That's one part. Corollary to the first one. So therefore, you'll have to address us how to, and this opinion of 2018, we are enforcing it now, which is 2025, after so much of gap. The fundamental question is whether do we have power to extend that period of limitation? You have to address us on that. You take it up next week, you address us on the period of limitation.
So my honest view is the matter is pending before the honorable court. That's the problem.
No, section 6A has already been determined by the Supreme Court of India.
But what will be the status of this man?
He'll remain a foreigner then.
Foreigner. He cannot be deported also.
We don't know what would the benefit, but he can't be registered as per the, so far as I remember, if my memory serves me right, under 6A, that has been clarified, it can't be done. But we give you time, since we have not examined that aspect. We give you time. Take it up next week.
2 weeks time. madam.
2 weeks. Okay. Mr. S.C. Biswas, and counsel of the petitioner, submits that by opinion dated 12 January 2018, passed, page 27, passed by so and so, no, opinion is at page
Page Malad 24.
24, page 24. Opinion dated 12/4/2017, passed by so and so in FT within bracket D case number so and so, SP border case number so and so. Comma, they were declaring the petitioner to have entered into Assam from the specified territory during the period between 1/1/1966 and 25/3/1971, and therefore she was held entitled to have a name registered under section 6 within bracket 6 capital A within bracket 3 of the Citizenship Act within 30 days. Full stop. Next, where it is submitted that the petitioner preferred a review petition, which was registered as miscellaneous case number 13 of 2017. This is at page 27, which was dismissed by order dated 12/1/2018, passed by the same said learned tribunal. They were dismissing the review petition. Full stop. Accordingly, next para, it is further submitted that prior to filing of the review petition, the petitioner had approached the foreigners registration officer, Sonitpur, Tejpur, by submitting a petition dated 9/7/2018, which was not considered. And therefore, the petitioner submitted a miscellaneous case before the foreigners tribunal. This para will go up, earlier para will come down, huh? Next para. In light of the mandate of the provisions of section 6 capital A within bracket 3 of the Citizenship Act, 1955, prescribing a period of limitation, the learned counsel for the petitioner shall address the court on the issue of limitation, considering the provisions of Section 29 of the Limitation Act, and also in light of the decision of the Supreme Court of India in the case of in Section 6 capital A of the Citizenship Act of 1955. Reported in 2024 within bracket 5 bracket close GLT 17. Next para. List on, give a date after 2 weeks. Before that you say that all the respondents are represented. Okay. Mr. Payam, you also address this. You said in the second paragraph, the land counsel for the petition, as well as the land standing counsel for FT matters, shall address us.
Yes.
Okay.
The next matter I prefer 14.
14, you want an adjournment.
But I have to go through the record, but
Okay. After 2 weeks? Okay. On the both sides are represented on the prayer made by land counsel for the petitioner. List after 2 weeks. Item 15. Oh, I'm sorry, I just saw Mr. Kohli. I forgot about the APSC matters. I just forgot. Mr. Kohli, you're not getting a voice. I think you are muted. Mr. Kohli, you are not getting a voice.
I'll ask Mr. Kohli to log in from some other device. He'll log in a minute, my lord. Some problem.
But it escaped us taking up these matters.
Yeah. Yes.
Today, who was to address us?
Mr. Das was in some difficulty today, so my lords had directed yesterday that any other council who wants to address from the appellant side, they can address.
I appear for item number 68 and 69.
We take up tomorrow because we don't have time today.
Yes, I'll inform the other councils also, Lordship.
Because in otherwise also in 10 minutes, you'll not be able to address us.
Yes, two notes.
Uh, Please remind me, when you take up matters, we get carried away. Tomorrow, please tell us again. Just remind us when we begin with this bench
Yes, Lordship.
to take up the matter. Otherwise, the tendency to forget.
So whenever your Lordship sits on this bench, then we'll remind your Lordship about the.
Yes, yes. Uh, Take it up tomorrow then.
All right.
All sides are represented. Due to paucity of time, this series could not be taken up today. Next, let the matter be listed on 15/5/2025.
Grateful for that, Lordship. I can hear you now. I'd logged in from another instrument.
Yes, yes.
I could not hear Lordship in the first part.
When this bench resumes tomorrow, please remind us to take up the matter. Taking up other matters, we forgot about this matter.
I will certainly do that, Lordship. I'm grateful for that and deeply obliged to Lordship and Ladyship. We'll tomorrow remind Lordship.
Okay. I was looking at Ms. Chaudhary and I was thinking she's in a wrong bench. I did not realize that you are in the right bench for a different matter. Okay. Item 15. There is no representation from the petitioner. All the respondents are represented. Stop. In the event there is a default in appearance of the petitioner on the next date of listing, my adverse orders would follow. List after 2 weeks.
Item 16.
Yes.
Kindly adjourn for the day.
Ele কিমান? ইয়াৰ পাছত, বান্ধিব নালাগে দি দিয়ে।
How much time do you need?
2 weeks.
You, you please find out when you address us next. There appears to be some incorrect statement made somewhere in your petition. Check up, do your homework when you come next. On the both sides are represented on the prayer made by Miss
Sir, that on behalf of.
S.R.
Mr.
Das, no counsel for the petitioner. The matter stands adjourned today. List after 2 weeks.
Organized.
Item 18 for admission.
The matter will be taken up any other day, like today's time is also not there. And I have to go through the records also.
Okay, both sides are represented on the prayer made by the land council for the petitioner. Matter stands adjourned today. List after 2 weeks. Other matters would be adjourned. We will not be able to take up. There's some official work we have to do. Mr. Sigdar and Mr. Viswas, can you come over to the chamber for 2 minutes? Mr. Viswas, and you please, there is something to ask you.
Well,